Hello, everybody, and welcome to Law Bite number 121, dated December 3rd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Law Bite is entitled District of Columbia versus Heller, 554 U.S. 570, 2008. For those of you who are not familiar with this case, this was the landmark 2008 U.S. Supreme Court decision that interpreted the Second Amendment to the U.S. Constitution as protecting an individual right to keep and bear arms inside the home for self-defense. The decision protected arms in common use, aka guns commonly used by the American people. And most specific to this case, the decision protected handguns. That's right, handguns, all right? So, with that in mind, D.C. versus Heller was the very first time in American history in which the Supreme Court interpreted the Second Amendment as protecting an individual right to keep and bear arms, okay? The court had interpreted the Second Amendment in the past, but never before had it reached this conclusion. The Heller decision was very controversial, but indeed, it was landmark and has had far-reaching effects. So, how did it all come about? Well, an individual named Dick Heller, who was a special police officer in Washington, D.C., wanted to register one of his firearms, but was barred from doing so by the district's very, very strict gun control laws. In fact, at the time, Washington, D.C. had some of the most punitive gun control laws in the entire nation, okay? So Mr. Heller indeed applied for a license to have a handgun at home, okay? But his application was denied, okay? And with that being said, Heller sued the District of Columbia, all right? As the law in question that he sued against not only so strict that it required the chief of police to approve licenses for handguns, but it also included provisions, that required individuals who owned, these handguns, okay, to keep them unloaded in the house, all right, and also to have trigger locks on them or have the guns disassembled, essentially making them useless. If somebody breaks into your house and your gun is unloaded and taken apart, what the heck good is it? It's not. Okay, bottom line. Okay, so Heller sued the District of Columbia, okay, alleging that these restrictions violated the Second Amendment's right to keep and bear arms, okay? Filing this case in the U.S. District Court for the District of Columbia, his initial suit was dismissed. He, however, appealed to the United States Court of Appeals for the District of Columbia, which ruled 2-1, okay, that the district's laws in question that were being challenged, okay, essentially violated the right to keep firearms in the home for self-defense purposes, all right? And DC's laws, okay, requiring that firearms be non-functional and unloaded violated that highly important right, okay? So the District of Columbia was a little perturbed at this fact and thus appealed to the Supreme Court of the United States, okay? And upon doing so, presented the court with a very simple question, all right? Did the laws in question in the District of Columbia that required the licensing of handguns and the handguns be unloaded and non-functional while kept in the home violate the Second Amendment? Petitioners for the District of Columbia argued, of course, that they did not, and that the Second Amendment did not confer any personal or private right to keep firearms in the home or anywhere else as a private right, as a matter of fact. Respondents argued the opposite, that the amendment indeed protected an individual right to keep and bear arms, okay? In addition to any other protection it may confer with respect to a militia, all right? Once the case was submitted, the Supreme Court would rule 5-4 in favor of respondent Heller. In an opinion delivered by Justice Antonin Scalia, the Supreme Court ruled, indeed, that the Second Amendment to the U.S. Constitution does indeed protect an individual right to keep and bear arms in the home for self-defense outside of service in a militia, and that individuals had the right to use that arm for traditionally lawful purposes, such as self-defense within the home. Indeed, okay, the court made it quite clear that the amendment is divided into two clauses. The prefatory clause, which states that a well-regulated militia being necessary to the security of a free state, okay, and an operative clause, the right of the people to keep and bear arms. The opinion emphasized that the prefatory clause, okay, did not increase or limit the scope of the operative clause, okay, and therefore the operative clause did indeed protect the individual right to keep and bear arms outside of service in a militia as an individual right, okay? The court also made clear that the decision, all right, protected arms, firearms, guns, aka, that were in common use. The decision did not require that such weapons used in war or other types of prohibited weaponry would be covered here, okay? Weapons in common use, okay? The court made it quite clear also that laws prohibiting certain types of individuals from having firearms, such as the mentally insane, those with drug or alcohol problems, okay, those with abuse, domestic violence issues. None of these types of laws would be called into question by the Heller decision, okay? The majority opinion emphasized that it was erroneous to interpret the Second Amendment to only apply to individuals connected with military service, as that would, in effect, produce a counterproductive result that the amendment was designed to prohibit. Thus, a disarmed people arrayed against a military force, something that the Second Amendment was designed to prohibit directly by preserving the state militias, okay, as a possible defense against an all-powerful U.S. Army, okay? So the Second Amendment, obviously, in the majority opinion and according to the majority's logic, had to be interpreted in the most consistent and logical, and I'll add, plain manner, according to the operative clause. And therefore, the operative clause guaranteed an individual right to possess firearms, okay, for the individual in case of confrontation, okay? Thus, it was an individual right protected by the operative clause, okay? And according to the majority, this is how the plain reading and meaning of this would have been understood at the time to the average individual, all right? It would have protected an individual right to keep commonly used arms for self-defense, okay? Not only with respect to service in a militia or some other type of military force. So the district's laws banning handguns, okay, essentially, which is the most common type of weapon used to protect the home, okay, arguably the most necessary area in one's life in need of protection. Thus, the district's law is prohibiting the handguns, you know, if not approved. And if you do have them, Okay. You had to keep them, like I said, unloaded and practically inoperable. The district's laws requiring all these things were therefore unconstitutional, in violation of the Second Amendment, because they directly inhibited the right to keep and bear arms in the home for self-defense and the ability to actually defend your home. Okay, bottom line. And that's essentially what Heller is conveying. So the dissent, okay, led by Justice John Paul Stevens, indeed held that the Second Amendment did not at all create an unlimited, unfettered right to possess and keep and bear arms, all right, for self-defense purposes, all right? He conceded, of course, with the plain language of the amendment, that it protects the right to keep and bear arms in connection with military purposes, yes, but under no circumstance does the Second Amendment inhibit legislative power to regulate the use and ownership of firearms. And indeed, according to history, the Second Amendment has never done that, okay? So, the Second Amendment has never restricted legislative power in that regard, as the majority would like to assert. But also emphasized in the dissent is that gun control has always existed. Okay, it existed before the Second Amendment and has existed ever since the Second Amendment was adopted. And thus the majority opinion, okay, is not interpreting the amendment properly according to history and context. All right. Now, so that's pretty much the summation of Heller, the majority, and the dissenting view. Now, interestingly enough, the conservative justices, 5-member majority, interpreted the Second Amendment, ironically, in a modernistic view. Historically, their decision is completely incorrect with respect to how the Second Amendment originally operated. And, again, ironically, the dissenters, who were the liberal justices, interpreted the Second Amendment in a very originalist format, something they don't normally do. Okay, the liberal justices normally interpret it according to modern viewpoints, not what it was originally intended to convey. Okay, so that's DC versus Heller. All right, protecting the right to keep and bear arms inside the home for self-defense, arms that are commonly used, not assault weapons or other things which are banned or typically used in warfare. All right. So if you have any questions or controversies about District of Columbia versus Heller, please leave them down below and I'll be happy to answer them. Anything at all, just ask. All right. And if you have not subscribed to my YouTube page, please do so. Just hit that little red subscribe button and we're in business. All right. Cool. Thanks for listening. Take care. Stay safe out there. And I'll talk to you at the next bite. Have a good one.